how to handle.
Oh, I'm not concerned with that. What I'm concerned with is tenants moved basically across the road, but they ended up in Ypsilanti Township. They were there for a while, whatever the agreement of their move-in was and the like. And I understood some of them, and some of them it was difficult to comprehend. But they were there for a couple of months, and then a lawsuit was filed against them by their new landlord, which was typically Beale. What I'm getting at is I don't know whether or not those cases still exist. Oh.
I hope that you have a
Where's Vincent?
Coach Mary's
Huh?
Coach Mary today.
He's down in C. You better go check because he's probably run off. Yeah, I know. What? Whoa. No.
Judge Dominic Camden appearing on behalf of the defendant. I was not expecting anybody else to be here this morning. We submitted to the court a proposed stip-in order following our last pretrial with the court.
All right.
Which resolves the matter completely.
Yes, I see that. All right. And I will sign that, and it's settlement agreement with dismissal. All right. Very good.
Thank you, Judge.
Is Robin, is it Piach?
Good morning, Your Honor. Ashwin Patel, Student Legal Services, appearing on behalf of Robin Piach. Billy Piach and Chase Piach are present as well.
Judge Dominic Camden on behalf of the plaintiff, Karen Steele, who is present.
Switch sides. We'll have to switch sides. My defendant. Him is over here. All right. Where are we? You guys need me or what?
I think probably, Judge. I don't think we're any further than what we were about 3 or 4 weeks ago. Counsel's looking for some information that I think I've got readily available for her, which we're prepared to turn over, but I don't think we're any further than what we were.
I think we need an opportunity to look at those responses, and then we can have a more fruitful settlement discussion and the documents.
Okay. So is there paper or there's documents you have not given over yet?
She submitted to me in turn discovery request this morning, Judge, looking for some information, which my client, and to her credit, is exceptionally thorough. I have a rather large box of stuff I just need to siphon through to turn over to opposing counsel to figure out what exactly she's looking for. So in other words, what I'm telling the court is I believe I have everything she's looking for. I don't think it'll take me long to turn it over.
All right. So what do you guys want me to do?
I think
I can give you another date, or I can sit and talk with you guys now, or what do you want me to do?
I'm okay with sitting and talking to the court now to get an idea as to what's going on. But we have a trial date scheduled, I think, for about 3 weeks out. That my understanding was
Conflict for me.
Yeah, there's a personal conflict for medical reasons, I think.
Got it. Okay. So why don't I pass the matter? Let me take care of else what I got here, and then I'll meet with counsel about it.
Thank you, Ron.
Right? Thank you. That's Arbor one.
Some claims I don't believe the tenant. I don't believe the defendant should. I do have the plaintiff.
Field. Defendant appeal, and they're not here.
Yeah, he did not check it.
He did not check in.
Correct.
And let's see if I can get it. Robertson Friedman versus Sylvester Smith.
Good morning. I'm here on behalf of Robertson Friedman. My name is Leaf Singh.
All right. And do we have Sylvester Smith? And it was, as I understand it, Robertson Friedman got the judgment. Defendant appealed that. He's not here. Defendant failed to appear. Appeal is dismissed. Judgment stands.
Thank you, Your Honor. Have a good day.
Who are all these other people? Huh? Why? Am I ready to call? Oh,
Yes, you are. Miss Gordon Lehman is in Zoom.
I call require. Is that the one?
Yes.
All right, court does call Arbor One West versus Rico McGuire et al.
That's it.
I have them, and then I've got, where'd Hamden go? It's like a squirrel. He just took off. I know. Okay. So I've got those two. Is it? Because if I step down, then I'm not sure. No. You get him, he'll just irritate me. No, I'm kidding. I'm trying to. March 1st, I said I was going to be nicer.
It's only the 3rd.
I know. I'm not real good at this. That's why New Year's kind of fell apart. Made all those promises, didn't happen. Huh? Okay. We didn't have to throw that out there like that. Thank you, Ann. No, I kept to my.
Mr. Henry's back.
I feel good about me. That's all I know.
You call the case, I asked him to pass it. Yes.
Are we ready on? Or-
Yeah,
Pardon?
think so.
You think so? All right. I'll recall Arbor One versus McGuire et al.
Good morning, Your
Go
Honor.
ahead, state your appearance, counsel.
Good morning, Your Honor. Deputy Gordon Lehman here on behalf of Arbor One, Arbor West.
Alex Henry on behalf of defendant Rico McGuire.
All right. Where are we on these cases?
So in this case, particularly for Rico McGuire, we talked with counsel. I don't think we have any counterclaims in this case. I don't think there's any escrow. At this time, I think both parties would be agreeable just to dismissing the case.
Okay, I don't have a problem doing that. However, what's happening with the rest of these?
Yeah.
And the reason I say that is because when we called the cases, because of the way these cases were filed, I've called it under Rico McGuire, and the other cases came along with it. So
Right. I think at this point, if there's no question of escrow for the tenants, I think in general, we are agreeable to dismissing those cases. So if there's a way for us to find out what tenants still have escrow, I think that could give us a clear picture of who we have no objection to dismissing and, having a conversation from there.
And do we have that list?
It is not an updated list, but I do.
You don't have an updated list? How long will it take you to?
10 minutes.
10 minutes? Okay. Then I can have that list and we can do those dismissals. Ann tells me 10 minutes. I'll give her 5.
Okay.
And no. All right. So anyway, we'll get that list of those. What else are we doing on these today?
Yeah, I think we're agreeable that that's probably the best course of action for all the cases that don't have escrow. There are a few tenants here today, I think, that do have escrow. They're going to be trying to request that back, and we may be assisting them in filing a motion to do that.
Okay. So, and I think I'm back at that same spot. Those tenants that have escrow, what in the circuit court, well, there's a circuit court matter, there's a federal court matter, as I would to understand. But what are those courts saying should be done with the escrow, if anything?
don't think they're saying anything expressly about the escrow. That does not seem to be a major topic of discussion in any of the ongoing matters. Um, and so I don't think at this point there's any clear directive on what is to be done with the escrow. I know that there was um, a prior process for tenants to apply under for release of those escrow, but I understand the court has said there's only been limited number of those that have actually occurred. Um,
Right. So that process that was in place before, I guess I need to understand, is that still in place and people just haven't used it, or did it go by the wayside somewhere? Because
We're a little confused as to what process Ms. Gordon is referring to.
there was a process by which the tenant would go, as I'm recalling, would go into Beale Properties. They had some type of an agreement.
Oh, the move-out
They-
agreement.
Right. They would go in, they'd sign that. That somehow or another got submitted to the court. The court then would release the escrow based upon that.
Folks that had the move-out agreement available to them. The judge didn't sign that order till I think late May. So folks that had moved out before then could not take advantage of that.
Okay.
And,
And that's fair. I'm just trying to figure out what then do I do with those tenants escrow who are in that other category?
So
I think it-
conversation, Your Honor, with Judge Conkey about the 14A District Court escrow. And she didn't say that she was going to order them to be released, because obviously that's in the jurisdiction, but she is in agreement that those should be released back to the tenants if it's for escrow during the period where they had no certificate of occupancy.
Or there was none.
Yeah.
Okay.
And I believe all the escrow is prospective. So none of it should be for a period that was before they lost the certificates, which was in September of 24.
Okay.
I mean, I think
So-
procedurally
Go
at this
ahead.
point,
Go
Your
ahead.
Honor, tenants would apply to your court via motion, and it would be in your discretion to determine if you want to release it or not. And we would have the opportunity to respond. I think procedurally, that would be the way in which if tenants wanted their escrow back, that would have to occur. I don't think there's any other directive other than that.
The court could sua sponte also release it under the circumstances.
Well, here's part of my concern with releasing the escrow. I've had the circumstance that I talked about where somebody was, and I guess it's a move out thing. I got that. But then we also had tenants who paid the money into escrow, but are now in another case, usually at 14B. And so then I would be signing orders and then drafted orders to release the escrow we had here to 14B to hold in escrow because that became their new landlord. And I don't know if we have those cases still out there too.
I don't know that we have any open 14B cases for the current 14A tenants. I believe those cases have all been pretty much settled or resolved in some way.
And we don't handle the Ypsilanti Township side, so we would not be privy to that. But I will say, just based on what Your Honor is saying, it sounds like some of these are different factually and, case by case basis. So I think it would be appropriate to have tenants motion for release of their escrow. And if the court is inclined for whatever reason, based on the facts to grant that, it's in Your Honor's discretion. But I don't think it should be a unilateral release of the escrow without considering all the factors involved with that particular tenant.
Your Honor,
Yeah.
if any escrow was released already to 14B, I don't think that this court would have to worry about that anymore.
Say that again.
escrow was already released to 14B District Court, why would this court be concerned with how to handle?
Oh, I'm not concerned with that. What I'm concerned with is tenants moved basically across the road, but they ended up in Ypsilanti Township. They were there for a while, whatever the agreement of their move-in was and the like. And I understood some of them, and some of them it was difficult to comprehend. But they were there for a couple of months, and then a lawsuit was filed against them by their new landlord, which was typically Beal. And then the tenant would go before Judge Washington's court and indicate that they have money in escrow. So then they had to get the money from here to 14B. In at least one of the cases, that was to comply with an escrow order that had been entered there. The other was just sent over and held in escrow at 14B. What I'm getting at is I don't know whether or not those cases still exist.
I think Mr. Henry's addressed that.
To my knowledge, I don't believe any of those exist at this time. But I can't speak for all the cases.
You're right. And I think that's part of the problem. So I've got, I have this here and it's all just a mess, quite frankly. But I think I'm going to agree with plaintiff's counsel that I'm going to have motions by the tenants. I don't think they have to be anything extensive.
Your Honor, we have promotions. Actually, Mr. Henry drafted some already. There you go.
We'll do our best to get those to the tenant so they can get those into.
There are, I believe, 3 or 4 tenants that we don't have contact information.
Pardon?
There are some tenants who have escrow that we do not have contact information.
Okay.
And you probably know that there was no mail at Arbor One for quite a while. I don't know what people did to forward their mail.
Well, if I get all of these down to 3 or 4 cases, I will be happy. Bless you.
And I will tell you, Your Honor, just so you're aware, to my knowledge, there's only one tenant on their current docket that is still actually in their unit. Everybody else, according to my records, has been accounted for as no longer being in their original Arbor One, Arbor West unit. Arbor One, outside of 3 buildings, is completely vacant. Arbor West, to my knowledge, there's 3 or 4 tenants that still remain, but they will be vacating or transferring by at least mid-month. We have 3 buildings that now have COCs, permanent COCs that are online. And so tenants have been placed in those. And so to the extent that there is a concern of folks actually still being in their units on your docket, that the one tenant, I believe, should be out mid-month. So there will be nobody.
So the one that is, just so I'm clear, the one tenant that's on my docket that is still residing there should be vacating mid-March or so.
Yes, that is my understanding. Yes.
Okay.
And Your Honor, I don't believe he has any escrow. So something that's the case can still be dismissed.
Correct. Yes.
Right.
Yes, absolutely.
I get that. Okay, so at this point, Mr. Henry, how many motions regarding escrow are you anticipating? Do we know how many we have?
Yes, I have 10 pluses and escrow. Do you want to know?
These are the 10.
Mm-hmm.
Okay.
I think we've been able to get in contact with 8 of the 10 that have escrow.
Are you?
No,
I know. Are you sure that okay, I just want to make sure. Are we talking about the same people?
I believe so. I can name them if that helps.
Go ahead.
Natasha Drake.
Well, why don't I do this? Because you've got your list and I've got my list. I think that's going to be in numerical or alphabetical order. I have Tashanti Cloakley.
Yes.
You got that one? Rhonda Chambers.
Yes.
Austin Vance.
Yes.
Jennifer Cook.
Yes.
Sharon Carson.
Yes.
Scott McDonald.
Yes.
Erica Reed.
Yes.
Andrew Miller.
Yes.
Lawrence Grove.
Yes.
And Natasha Drake.
Yes.
Those are all the ones I have.
To be clear, we don't have contact with Deshante Coakley and Rhonda Chambers.
Got it. So
What
we
was
don't.
that? I'm sorry. What was that first name you said, Alex?
Deshante Coakley.
Oh, okay.
Tashante.
Gotcha.
You don't have contact with that person, right?
Yes.
And who else?
Rhonda Chambers.
Okay, my first two. The other ones you have contact with and could file those motions, right? Any of these, and again, this gets a bit confusing for me because they moved out. So you're going to be proposing that the escrow be released to them,
Yes.
right? Not to their landlord, their current landlord, or anything along those lines.
Directly to the defendant.
So how many people are here right now? 1, 2, 3, 4, 5. Well, hold on. Are you guys together or you?
No, I don't know him. We're just related.
Pardon?
I don't know him. We're just related. We're separate cases. So I'm Austin Vance Grove, and this is Lawrence Grove.
I don't know him, but we're related. No, I'm gonna tell you, I have some cousins like that. Where I will tell them but I don't know them, but we're
I have
related.
a brother like that. He's right here.
Okay.
We don't really.
So there are 3 separate cases. Right?
We're
Two separate cases.
two separate cases. We're Austin Vance and I are in the same unit. That's my boyfriend.
They do have two.
Remember you called him annoying 6 months ago? It was great. I loved it.
What? I called somebody annoying?
Yeah, you called my boyfriend annoying. It was great. You just confirmed what we already knew, okay?
Well, I'm glad I could make you happy. All right. So, and this gentleman over here, what's your name? Mr. Hicks. Okay. I don't have any escrow for you.
Mr. Hicks does not have escrow. That is correct. Neither does Mr. Mustafa Hadake, who also raised his hand.
So those cases are going to be your case and who else?
Mr. Mustafa over here. on the left.
Okay, so those are going to be dismissed, right? I think everybody's in agreement on that. All right. So you have a form motion to. But I have how many? I have 3 tenants then that are here. Is that right?
3 tenants with escrow.
With escrow.
Yes, I believe so. Mr. Miller and Groves.
Oh, Miller is here.
Okay, so I have those 3. All right.
Do you have the files or for those?
Well, yeah, what I'm going to do is I'm going to step off and what I'd like to do is I'd like to get rid of as much as possible. So those cases that are going to be dismissed, I'd like to do that on the record. We'll have to sort them out. Right. And then the ones, I guess if counsel, would you waive? Because I'll set another date, but the 3 that are here, I don't know if there's going to be any objection to the escrow that's there to be released.
It's not clear to me who's there, Your Honor.
Okay, very good. That's fair. Who do you have?
That'd be Elisa Grove for the Austin Vance case.
Grove for the Vance case.
They've got 2 cases, but escrow's posted in 1.
I have Austin Vance.
Yeah. She's only listed on 1 of the cases. I believe the escrow is in the case just in his name.
Right.
Yeah, then there's Lawrence Grove, also has escrow.
Lawrence Grove. Well, this isn't making any sense. Okay, I have Grove. Where's Mr. Grove? Right there. Okay. And then let's go back to the Vance case. Who's here on behalf of Vance? And your name?
Elisa Grove.
But
My name is on the lease that they didn't have. This was a whole thing before.
But the case, here's going to be the problem. The case that holds the escrow.
Is Austin Vance, yeah.
Yes. So that motion's going to have to be filed because that's the only way it could be released is to him.
Okay. The motion is in his name as well.
Pardon?
The motion is in Austin Vance's name.
I regave her a motion to
Okay, all right. Very good. And then who was the other one?
Andrew Miller.
And Your Honor, could you confirm how much are in those 2 escrows?
In Miller, you're talking in Miller and Grove?
Correct, Your Honor.
All right. Yes, I could do that. In Miller, there is $1,516. When you put AO up there, they deposited that.
That was from Arbor 1, correct?
Right. So that was from Arbor 1, but it was rent that was paid in.
Correct.
The tenant paid the rent, but Arbor 1 deposited the escrow
Okay.
on that one. And that's on Miller. So there's $1,516 in Andrew Miller's escrow. In Grove, the defendant deposited this, there's $820.
Okay.
Okay, so if there's not going to be an objection, I think I can take care of those 2 at least today. The other ones would have to be filed. And so what I'm going to do is give my staff a chance so I can dismiss those that I can dismiss. Do you have orders on the escrows? Proposed orders?
I think I do have those, yeah.
Okay, so I would accept or at least look at proposed orders on Miller and Grove.
And Your Honor, I can't affirmatively say at this point that we wouldn't object. Now that I know who they are and how much is in their escrow, I will,
You would be objecting on
I
what
need
grounds,
to,
I guess.
I need to inquire with the property management team directly now that I know who these individuals are and how much is in their escrow. I think there's always been a question of arrears prior to the non-COC period. So I think
Oh,
if there were
prior to the
arrears,
time.
yes, I think that would be a question that I need to confirm on these specific tenants. And then I could advise the court whether or not we would be objecting.
Okay, then let's do this. Let's do it this way. I was hoping to try to clarify those if we could. So I'm going to let my staff organize the file so I can get rid of what I can get rid of. Then with regard to the motions, are you prepared to file those motions today with the exception of the two?
For all the other tenants?
Yeah, for those that are going to be left, are you prepared to file those today?
I'd have to get in touch with those tenants because we don't represent them in court. So we'd have to get those to them and then have them send those in.
Wow. So if you give them that motion, so you're not representing some of these folks, right?
That's correct. We can, but we just have not put in an appearance yet.
Yeah, okay. Well, this is going to be a little bit difficult in terms of scheduling it, because the motion's going to have to come in, give plaintiff an opportunity to look at what claims they might have, and then the court's going to have to be able to look at that and rule on it. All right, all right. How long will it take you think, to get in touch with these individuals to get either an appearance entered or some authority to be able to file a motion?
I think we should be able to do that by the end of the week.
By the end of this week. Okay. Better than what I thought. So I don't have a Tuesday until April 14th.
No, sir, you have the 10th and you have the 17th of March.
Right, but
And then after that, correct, not until April 14th.
okay. And counsel, after you get it, you'll be able to get in touch with your client as to where your claims may be regarding these, correct?
Correct. Yeah, we would need to look at each one of these and kind of figure out what's going on with that particular tenant and their ledger and account to determine if there's any basis to object. And so.
So do you have, counsel, you don't have the list of who we have escrow on? Is that correct?
Other than, Your Honor, just reading the list of those 2, 4,
Those names?
8, 10 names, I don't have anything else formal. And I don't know what would be in those other tenants' escrow accounts either, amount wise. So.
Gotcha. Okay. That's what I was trying to get at. And you guys don't have the amount of escrow for those.
I think we do, for maybe everyone except Natasha Drake, which may be out of date.
Okay, so here's what I'm going to do. I'm going to, if you can have these in before the end of the week, I'm going to set these for escrow hearing on escrow for March 17th. Because otherwise I'm not going to have anything till mid-April. So I'm going to try to do this as quick as we can. But that means the motions have to be in. Counsel, if you end up in a circumstance certainly we would like a written response, but I will take and address any oral objections that you have
Okay,
because of the limited time frame. So I'm not going to hold you to try to get something in writing specifically, but I would try to deal with any oral objections that you'd have to release of the escrow.
and Your Honor, I apologize. What time would the 17th be? I have a deposition scheduled that date.
Do you? What time's your depths?
My deposition starts at 12 o'clock in person in Troy.
Okay, so let me set this at 9, and can you put on there? We'll get in and address these right away to get you out of there. Okay.
Thank you, Your Honor.
And what we will also do, Counsel, is I'm going to have my staff. So while they try to arrange all the dismissals, and then I'll come back out, we'll dismiss those cases. I'm going to have and send over to you our printout with the escrow amounts on them so that you can see that for each of the tenants.
Perfect. Thank you, Your Honor.
All right. Now on them, so that you know, so this is their marking. There is, after each number at the top, you'll have AO or you'll have defendant.
As the hearing moves forward, the courtroom atmosphere becomes more complicated than anyone expected. The judge begins carefully untangling the timeline of events surrounding the tenants, the escrow money, and the series of legal disputes that followed. At first glance, it seems simple. Tenants moved out of their original units and relocated just across the road. But legally, things are rarely that straightforward. The judge explains that many of these tenants didn't just move buildings. They moved into a completely different jurisdiction in Ypsilanti Township. They stayed there for a period of time under various agreements with a new landlord. And that's where the legal confusion begins. According to discussion in court, some of those agreements were unclear, and even the judge admits parts of the situation are difficult to follow. Then things escalated. The new landlord eventually filed lawsuits against some of those same tenants. Now the court faces a much bigger question. Do those lawsuits still exist? Are there active cases still pending in another court? Because if they are, that could directly affect how this court handles the escrow money that was originally deposited. In other words, if another court already has authority over a related dispute, this court must proceed very carefully before releasing any funds. That's why the judge pauses the discussion and makes something very clear. Before the court can decide anything about the escrow money, the timeline of these events must be fully understood. Were the tenants still under obligations from the first property? Did the new landlord file claims that are still active? Or have those disputes already been resolved elsewhere? Until those answers are confirmed, releasing escrow funds could create conflicting legal decisions between different courts. So for now, the judge chooses the safest path, requiring formal motions from the tenants before any escrow money can be released. That way, every claim, objection, and financial record can be reviewed on a case-by-case basis. It may seem slow, but in court, careful procedure is often the only way to prevent bigger legal problems later. Because when multiple landlords, courts, and contracts collide,